No, this morning the Hawaii Supreme Court made a ruling on the Kalkini case. As a result of that ruling, it is our understanding that the archaeological inventory survey for the project must now be completed in full prior to being able to move forward with construction. As a result of that, it is clear that there will be, as a temporary setback for the project, there will be some delay. Our intention is to diligently complete that AIS work, and as a result of the completion of that work, we then hope to proceed to get the final approvals and the complete project by Shipney and move forward. Obviously, it's a large ruling. It's 80 pages. Our attorneys are still looking at the other aspects of the ruling, and I know that we're also reaching out to counsel for the plaintiffs to understand where they'd like to go next as well. So while it is a temporary setback for the project, and obviously the requirement of us to now do this additional work, that's where we believe we're at, and we look forward to the Board of Directors meeting next Thursday. We'll have a chance to fully brief our board on what the contents of the ruling is, and also be able to impart to them any additional information that we've been able to receive as a result of consultation with the plaintiffs' attorneys.
Will you be halting construction and when?
So as of Monday, Tuesday, Wednesday, prior to next week's board meeting, most of the construction activity that was to take place along the alignment is column construction where the ground has already been disturbed for the foundations. I am again consulting with folks, our attorneys, as well as talking to folks at Kiewit to exactly understand what types of ground activity may be taking place, and look forward to addressing whatever council may advise us to do, and whatever kind of work may be done to determine if there's any alterations to the work schedule.
Native Hawaiians, is that a halt? Or?
Does that mean you're still going to consult, so you're not going to stop construction until you get an answer back from Kiewit?
Well, just that we're trying to get an answer from them in terms of what kind of construction. Obviously, what we want to do in good faith is to limit any ground disturbing activity as was requested by the plaintiffs. Since we have a board meeting that's been previously scheduled for Thursday morning, this will be an opportunity for us, in my case, to fully brief the Board of Directors and also to consult with them and give them information. Again, where the ruling took place only first thing this morning, we want to make sure that we understand a few things. What does the court case actually say? What are the plaintiffs actually asking us to do? What we think that the court, since it's been remanded back to the circuit court, what type of actions we may think deem prudent to take prior to going to circuit court, or we may want to wait and see what circuit court has to say. So there are a number of different questions that I'm not in a position to be able to answer without some additional information.
Thursday morning with the board?
We have a board meeting on Thursday morning.
Why not meet before then?
As was previously scheduled, and given the fact that it's going to take a couple of days, it's now the weekend, a couple of days to digest the actual report itself. I understand that the plaintiffs have asked for some sort of communication back to them on Monday morning, so we want to give it a couple of days to find out exactly what all the parties are intending, and also what the case actually says. Again, it's 83 pages of dense information.
How long of a delay are you anticipating?
Well, right now, our archaeological inventory survey and the schedule that we're currently looking at would have us completing that sometime in the first quarter of next year. And so the question would be, is there a responsible fashion that we could accelerate that activity and still be mindful of our duty to do that in a responsible fashion, but also do it sooner. And so I've asked staff as of this morning, since we saw the ruling, to actually give me a sense of what the schedule is today versus what it might be if we try to accelerate that schedule and accelerate the work. You know, for instance, it can still be done responsibly, but perhaps adding additional crews to actually do the trenching of the analysis.
And I'm sorry, what is that timeline?
That's being determined right now.
Have you alerted the FTA, and if so, what did they say?
We have. First thing this morning, with our attorneys as well as FTA's attorneys were notified. I spoke briefly with the Region 9 administrator and let him know about the ruling as well.
How does it affect the FFTA?
Hopefully it won't at all. Again, this is a temporary setback or a delay in the project. The court has set forth that there is a necessity to undertake certain activities in a different way than the city understood them and the state understood them. As I read the case myself and have been advised, but the Supreme Court says that the city and the state were in error in terms of how they understood those rules. They've now said this is how the activity should have been conducted. So now we simply have to follow their direction.
So, do you believe this could have any bearing on the lawsuit involvement?
Two different things. This has to do with state law.
Dan, if the ruling essentially says, I believe, you can't disturb any more earth. So you talked about continuing trenching, but what can you actually do if you can't disturb any earth?
No, actually, as I understand it, the plaintiffs specifically said that they were looking for us to look at ground disturbing activity other than the trenching activity. In other words, their intention is
continue the AIS, but all other construction stop.
That is my understanding.
So how will it change if you do find the easy now? Well, I mean, as opposed to before.
It's not. Nothing changes in terms of what we were doing. It may change when we were going to do it, but the only difference is that rather than having the activity move forward while there's still some work to be done, the Supreme Court ruling, as I understand it, is we must complete all the AIS work, package that up, have it reviewed, and then receive your approvals.
But if the ruling calls into question the shifting ruling, the SMA permit ruling on which that is based, and any other permits that follow from there, under what justification can any work continue?
Legal question.
Maybe we'll ask you later when your mic's up on.
Dan, political setback. You know, we have an election in November with an anti-rail candidate, pro-rail candidate. What do you think politically?
You know, I don't know. Right now I'm looking at this as the person who's in charge of managing the project. The city undertook these activities on approval from the state. My understanding is the state interpreted the rules that they conduct under in a certain way, and the Supreme Court has said that was an error. So what they've said is this is the correct avenue, and so we're following that. So again, I don't view it as anything other than unfortunate temporary setback. If there's delay, maybe there is delay, it's going to be additional cost. We'll have to deal with that as we do.
What is the cost?
Worst case scenario. Again, to be determined. I'm still fact gathering in terms of what kind of activities were anticipated over the next several months, and then how quickly we might be able to accelerate the archaeological inventory surveys so we can complete that and meet the obligations of the Supreme Court.
This is only one of several lawsuits, and in the past the administration and part in the past has characterized the odds of these other lawsuits prevailing, of the plaintiffs prevailing, as slim tonight. And we see today that the first of them to come out is in the plaintiffs, largely in the plaintiffs' favor. What do you want to say about that in retrospect?
Well, prior to my time, and I'm not an attorney, so I really can't opine as to that. I can just tell you that what we're looking at right now is a situation where the state and the city acted in accordance with what they understood the laws to be and how those laws should have been followed. The Supreme Court has said should have gone this direction, and so our job now is to comply with that.
Governor Toronto is kind of referred that he's not specifically but hard rest the project and it's going to cost the taxpayers because of these delays. What's your reaction to that?
Well, again, in this particular case, I would say that the city was acting with the approval of the state agency that had to interpret their own regulation. What the Supreme Court, as I understand it, said is, well, you may have interpreted that in good faith, and they said that the interpretation was incorrect.
Was the department at all prepared for this type of decision, and surprised that it did come out this way?
Well, clearly, you know, we've been working in good faith under the interpretation of the law and the approvals that we were given. Certainly, we're disappointed that this temporary setback is facing the project at a time when we've actually started construction. But we're responsible to follow the law, and the Supreme Court has outlined what that legal remedy is, which is complete the AIS, go back to the state, have them approve the completion of all that work, and then we'll be able to move forward as the law requires. So Phase 1 and Phase 2 of the project, all of the AIS work has been completed. In Phase 3, I just want to check my notes. In Phase 3, we have 35 trenches that are yet to be completed, out of a total of 40 we're identifying, and we have 173 city center yet to be completed, and that was out of a total of we completed 59 of those trenches.
How much for the total?
59 in the city center they completed. We have 173 to go, and we completed 5 in the airport center, and we have 35 to go.
What would you say to someone who might challenge the assertion that it's a temporary setback if all of these approvals might have to follow from it again? The SHPD, the SMAs, and all these other things. What in your mind is temporary?
Well, it's just that rather than, what the Supreme Court ruled was very clear, that rather than segment the project and have individual, have the approvals pending those individual completions in the 4 sections, we need to complete the whole thing. So it's a different manner of complying with that process. So instead of doing 4 pieces, they're asking us to do 1. 2 pieces have been concluded, and the other 2 are in the process of being concluded. We'll have to wrap that all together now as 1 package and then bring it forward to shipping.
It might be more along the lines of in a project in which HART itself has said every month of delay costs us X million dollars. How are you defining in time? You're calling it temporary.
Well, again, several people have asked questions. Right, I can't answer that question until I know what the archaeological inventory survey schedule is, how it can be accelerated in a responsible fashion to still do all the necessary work, but to do that a little bit quicker than we thought we had outlined. And then also, once we determine what that length of time is, then we can also see what sort of work was anticipated in the field that may now have to be temporarily placed on hold. And I think that's going to be, again, a discussion that we're going to be having and understanding what the plaintiffs are seeking, as well as what the circuit court, in looking at our case, would now have to say about what exactly is defined as the type of work that's being addressed by the case.
How much do you plan for this scenario in advance as far as
exactly the judge may rule in whole or in part, or how that ruling will go. And so what I know is what we have today, which is the Supreme Court having said all AIS work must be completed, submitted, and approved prior to construction incident.
so you guys here?
Well, again, not knowing exactly what we were going to be faced with from one end of the spectrum to another, absolute sanction. The Supreme Court did uphold the environmental impact statement that was done. It did uphold that we had done it properly. So that's a significant and important decision that was rendered here. Also, the Supreme Court took the recommendations from the plaintiffs, the request from the plaintiffs for certain actions, and set those aside and said, well, there's more information that needs to be collected, so let's send that back to the circuit court and let them decide what the remedy might be. And so, there was no immediate action. There was no enjoining of activity, for instance, by the Supreme Court today. So that's one of the difficulties with trying to guess credit.
What have you told contractors?
Certainly, we've informed them to the degree that they weren't already aware that there has been a ruling on the case. And again, as I've told you, until we really get a chance to digest the case fully, it was only issued a few hours ago, we'll then inform them what that means.
Dan, what is the total amount of change orders to date, and then what's the estimate of every month that the project is delayed, how much more cost you would incur?
I'd have to get you that information.
What's the estimate per month of how much cost you would incur for every month of delay?
Again, it's going to depend on gauging what activity is going to be affected by the case. To the degree that the case is focused on ground disturbing or ground altering activity, i.e. construction, people think of, that's a different question than it involves other types of activities that we're undertaking.
The plaintiff's attorney says there's no real wiggle room for the circuit court judge if it goes to that the judge essentially has to order construction to stop.
Again, that's going to be a conversation with the plaintiffs and certainly with the